State would like or prefer a final order, but anticipates that this might become a temporary one. The primary conflict in this case is going to be access and possession. I believe that there's going to be some testimony regarding some safety concerns and possibly a pending charge, assaultive type charge against the non-custodial parent.
All right, then, whoever's asking for something, well, the burden of proof falls on you to give the court the data and information that gets to the point where the court can deviate from what the law says I'm supposed to do as far as conservatorship, visitation, so forth and so on. And until somebody actually has a conviction or has pled guilty to a criminal matter, then that person is considered innocent until it's proven differently. And the court will not go into details as far as anything that's pending, because the court will automatically invoke the non-lawyer's Fifth Amendment right against self-incrimination. So if you've got something that you one side's trying to prove up on the other, the burden will fall on you to give the court necessary proof that shows that that did happen. And of course, it's not like criminal law. Civil law is by preponderance of the evidence or by clear and convincing. It's not beyond a reasonable doubt. But again, I've got, like I said in my morning speech, I got to hold you to the same standard as if you went to law school. And so if you're asking for something that's different outside the what I'm supposed to order, that burden falls on you to give me that legal proof. So at this time, I'm going to go ahead and swear both of y'all in. I'll see whether or not the information rises to the criteria that the court will have to see about making this attempt, and whether or not it's sufficient to deviate from what the standards are as far as a suit-affected parent-child relationship case in the state of Texas. So at this time, Ms. Brown and Mr. Woodard, both unmute yourselves, both turn on the videos, and both raise your right hands, please.
Trying to see how to raise my hand, sir.
Okay, well, okay. Sir, if you can't get the video, okay, if you can't get the video going, just raise your real right hand. That doesn't count. Okay, just raise your real right hand. Do both of you solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth shall help you?
Yes, sir.
Yes, sir.
All right, you're both officially under oath, and I'll allow the state to call you both as witnesses, and we'll see what's going on here. So at this time, Mr. Gwynn, you may proceed. Thank you.
Thank you, Judge. State would first like to submit State's Exhibit 1. That's going to be the DNA or positive DNA testing.
Right. At this time, folks, the court is showing you State's Exhibit number 1, which is the DNA paternity analysis in your case. Is there any legal reason, Ms. Brown, this should not come into evidence? You muted, ma'am.
Okay, I'm sorry. No, sir.
All right, Mr. Woodward, any reason?
No, sir.
All right, Stage 1's admitted. Stage 1 shows that Mr. Daniel Woodard cannot be excluded as a biological father of the child before this court. Probability is with the guidelines set forth by the family code of being 99.99, and this one is 99.999999997. So that's well within the guidelines with a combined paternity index of 4.3 billion to 1. The court will also find that Mr. Woodard is the child's biological father. You may proceed at this time, Mr. Gwynn. Thank you.
Thank you. State would like to call Daniel Woodard.
I'm able to speak now, sir.
Yes, you are. Please state your full name for the record.
Daniel Isaiah Woodard.
What is the name of the child that we are here on?
Kaj Abijah Brown.
And how old is that child?
Kaj is 8 months now.
What other children do you have outside of this order?
None, sir.
How much do you currently make an hour?
$15.30 an hour.
And how many hours a week do you work? Do you work full 40?
Yes, sir. I work a full 40.
Okay. What are you asking the court to do here with regards to access and possession?
Just proper visitation. I would like to be able to have Kaj on weekends or just basically whenever I'm allowed to be able to have them. Also holidays as well. And because a lot of my family is out of town, it's hard right now to be able to actually even allow my parents to even be able to come see him or me take him to them.
Okay. When were you last arrested?
I was last arrested December 23rd. I got booked December 24th.
Okay. And what was the alleged charge that led to that arrest?
At the time they arrested me, they said for assault of a family member.
Okay. And what, if anything, has come of that charge? Has there been any conviction, acquittal, anything like that?
No, sir. No, sir. But I do believe that I'm going to be acquitted of it because
Okay, sir.
shortly after.
It's still, sir, you can't speculate on something like that. You have to, I just have to wait and see what happens. But the bottom line is you have an attorney.
For that, no, sir.
All right. Have you asked which county is this pending in?
Kalina, I believe.
Okay, that's Bell County. And have you been to court yet and given opportunity to get court-appointed counsel?
No, sir, I have not.
When's your next trial date or next hearing date, sir?
They have not told me yet. I check in with a bail bondsman every Monday, and they basically are the ones telling me, like, hey, we'll keep you updated when we do find there's a court date. So I check in with the bail bondsman and I just go from there.
All right, thank you, sir. You may proceed with the next question, Mr. Grannon. Thank you.
State has no further questions for this witness at this time, Judge.
All right, over. I got one final question, sir. The person that this alleged assault took place against, was it Miss Brown or someone else?
No, sir, it was someone else.
All right, okay. And how is that person related to you, sir?
She isn't related. What it is that she was a friend of mine that was needing a place to stay.
All right, then. All right, then. Thank you very much, sir. And I'll go ahead and let the state proceed with the next. Any other questions of this witness at this time, Mr. Grannon?
Not at this time, Judge, no.
All right, then. Sir, I'll be back in just a moment. Call your next witness.
State would like to call Jada Brown.
Yes, sir.
Please state your name for the record.
Jada Ashley Brown.
And again, what is the name of the child that we're here on?
Kosh Brown. Kosh
Who's the father
advisor.
of that child?
Daniel Woodard.
How is that child currently receiving medical insurance?
He's on Medicaid.
And what are you asking this court to do regarding the access and possession schedule of this child?
I just asked for supervised visits. I just want to make sure that my baby's safe. And
Why?
well, I was trying to maintain the visitations between us at first, being that we had such a long wait for court. We ended up having an incident where Mr. Woodard got pretty belligerent in my house and was cussing me out in front of my family and my other children, and was continued to cuss me out outside my house. When I had got up to get my baby, he claims that I snatched the baby, but I did not. I just grabbed the baby and was trying to tell him to please, leave my residence. I don't think he was
Stop. Remember, testifying into a narrative, you're going a little bit past the question. I'll have the state ask you the specifics, but you're not allowed to talk and tell me a story. You got to listen to the question, answer the question, and stop. Thank you.
Okay. Well, yeah, we had an incident that led to me getting an incident case number with the Harker Heights PD at my house.
So the police were called?
Yes.
What became of that police report?
He ended up leaving the residence, so they just gave me the case number. I didn't really go any further, just kept the case ID number.
When did that incident occur?
I believe this was in November, right before Thanksgiving.
By November, you mean November of this last year?
Yes, sir. 2025.
When did you and Mr. Woodard separate?
It's been over a year.
When we previously talked, didn't you tell me it was a year and a half?
Yes, sir.
What are you requesting with regards to retroactive child support?
Just whatever is due to the baby that the court sees fit.
What are you requesting with regards to child support or guideline child support?
That he just receives the guideline child support.
Medical support as well?
Yes, sir.
No further questions at this time for this witness.
All right, ma'am. What kind of visitation access has the father had to this child prior to today's hearing? What has been done? Supervised, short visits, overnights. What have y'all actually done? Baby's really young, so I'm trying to figure out what I want to try to do. So, what has been the history in this matter?
I have allowed him to come over every Sunday and Wednesday because he works every day typically, and his days off is Sunday and Wednesday. So I typically allow him to come over on those days and come sit and spend the time with the baby. Um, Being that I work on Wednesdays, typically he'll come over after I get off, but he's able to stay as long as he can because we both do like religious practices. So after church, before church, whatever, whenever he has time, honestly, I've allowed him access to the baby.
And how many times have he's actually exercised that access on him?
He was coming fairly common, except for just probably the last month of it. It seemed like he kind of started coming later and would leave earlier.
All right, and what's the total number of times, if you give me a best estimate? More than 10, less than 10? What are we talking about?
As far as how many times he's just came to visit,
Yes, sir. Yes,
regardless.
ma'am. Yes, ma'am.
More than 10, more than 10.
Okay.
He would come
And you
faithfully.
both live in Kalina?
I live in Harker Heights.
Okay. There. And man, what do you do for a living, please?
I work for KISD.
Uh,
Yeah, after having the baby, I just started in the kitchen.
okay, no, never heard
I'm a
of those
lunch
guys.
lady. I'm a lunch lady.
No, I'm sorry. My mother taught for KISD for 30 plus years. So yeah, I think I've heard of them a few times. So
I'm trying to work my way up the ladder.
okay. All right then. All right then. You may proceed with the questions at this time, Mr. Gwen. Thank you.
What are you requesting with regards to non-disclosure?
It doesn't matter to me.
So you understand that would determine whether or not your contact information, such as your address, phone number, etc., are going to be included in the final order,
Yes, sir.
and that is not of importance to you. You don't have any safety concerns with regards to that.
No.
Okay. But no further questions for this witness at this time, Judge.
All right, guys. First off, no other witness is correct, Mr. Gwen.
That is correct, Judge.
All right, folks, I've heard enough here that I could probably go either way, temporary or final. The fact that the alleged assault took place against a third party, I'm really not anxious to wait to see what happens on that because it's just at the beginning, and that we could be sitting here this time next year and we still could be waiting for something to happen on that case. And since it's not a case against the mother, then I'm reluctant to go ahead and stretch this thing out based on that circumstance. What normally the court does, and I'll let y'all know up front, under Texas law, there's a couple different standards. Number one, there's a standard for standard visitation or standard possession over the age of 3 and under the age of 3. Technically, it could be still the full standard, but the court has leeway to do things differently. Sounds like y'all were doing the break-in visit. Well, y'all were doing the visits with mom being present, but the court has the absolute right to continue that. But I also have a absolute right to put a cap on it, and my cap is usually somewhere between 3 to 6 visits, and start getting dad to start moving toward a standard possession order by starting out with visits with the mother being present, and then switching over to dad being able to pick the child up for, well, his visitation is usually for 4 hours when you started that out. Dad comes over and visits for 4 hours and then leaves. After that, the next level up after that, dad gets to pick the child up for 4 hours. And I can do that anywhere, any number of times I want, 3 to 6 or 3 to 12, since the child's such a young age. Next level up after that, dad gets to pick the child up all day Sunday or all day Saturday. Obviously, it sounds like y'all are Sunday people. So that's like that again would be from 9 to 5 on Sunday. And the final level up after that would be dad would get to pick the child up for overnight visits, and I'll have to figure out how to do that one based on y'all's scheduling. But again, the whole idea is to get the father to standard possession order as soon as practical. Again, y'all had this child together, and I'm supposed to do that and get that done as soon as it's practical. And again, I can do it up to 6. I normally do it up to 6 visits, but because this child is under the age of 3, that 6 visits is when I look at kids over the age of 3. So I'm probably looking at something maybe a little different at this time. So if I was to go ahead and do, but I would do, since he's done so many visits already as far as being present, I didn't get any testimony how long they've usually lasted, but you say they've gotten shorter over the time frame. I'm probably looking at starting back out at 6 visits on either Sunday or Saturday. And again, sounds like Sunday to me, with mom being present. And those visits will be from 1 to 5 on Sunday. And then after that, we'll start looking at dad being able to pick the child up for 4 hours. So at this point, ma'am, is there a reason I should not go for start doing that break-in visits to get dad where after he completes all levels and all visitation, he gets to have the standard possession order, which means weekends, summers, and things like that. And again, when the child is so young, I do not start 30 days in the summer or 42 days in the summer until the child's over the age of 3. So even if dad was able to work to all these other things, the visitation for summer until the child gets to 3, will be age of 3, will be somewhere between a week and 14 days. So based on that criteria, ma'am, and I'm gonna come back to you. I'm gonna come to you in a moment, sir. We'll see what you want. What would you request the court to do?
I think that sounds okay, especially with the age of 3. Just for the baby safety is how I feel. I just want to make sure that my baby's gonna be okay.
But ma'am, he can say the same thing. Again, the law takes it for granted. Y'all are always going to do the right thing when it comes to taking care of the kids, unless there's been a criminal conviction or protective orders like that against them or something along those lines. Then I've got to, everybody gets that benefit of the doubt. I give you that benefit of the doubt. I'll give him that benefit of the doubt.
Yeah, I understand because so additionally I had tried to get a protective order. They told me I didn't have, I guess, enough. But that's neither here nor there. I just want, I would say, supervised visits until he's 1, because we only got a few more months until he's 1 in May, and then he can come and pick him up if that's fine, for a few hours and take him for a few hours. Or I can drop him off because I don't know how he would transport him. He doesn't have a vehicle. And then, however,
under Texas law, so long as you live in Bell County, it's supposed to be pick up and drop off at your residence. But if everybody feels safer going somewhere else, I always make the pick up and drop off at either KPD or HHPD based on y'all circumstances. So or you can, like I say, you can do it yourself. But again, the norm is it's his responsibility as the non-custodial party to pick the child up and drop the child off.
okay, yes, sir.
All right then, man. Even based on this being February, if I was just to give the 6 to 8 visits, if he did every last one, it would end in May. So yeah, well, if he did every last one, it would end in April. But that's a little tougher than said, and a little tougher than said than done. So anyway, is there anything else? And I'm getting ready to go to dad.
No, Judge. Thank you, sir.
All right then, sir. You heard what I'm looking at doing. What's your input on that, sir?
So yes, sir. That part is fine. I am fine with doing the 6 visits. And then, but also I would say that because that I haven't been actually able to even physically take Kaj anywhere or even have my visitation with him, just me and my son. I'm looking at honestly that it should only be right, especially since, you know, she did bring up, you know, the protective order that she did try to place on me. The thing is that, you know, even like I was explaining to Ms. Brown, you know, it is just practical for me just to come pick him up and just have my visit with him and then bring him back. And the thing is that even when I have another judge telling me, Mr. Woodard, leave Ms. Brown alone, and me actually saying, okay, well, I have to be practical because I do need to leave her alone in any other type of sense of the word, but at the same time, I'm still trying to be a father to my son. So I want to be able to just
Well,
be
here's the
able
deal,
to
sir.
keep.
You're gonna have a court order. I'm gonna make this a temporary. It sounds like I gotta make an attempt at least to get through this first set of visitation. So again, you all of a sudden you got a court order that says exactly what your rights are and what you need to do. So that takes care of a lot of those concerns one way or the other. And sir, what family do you have local?
So right now, I don't have any family local, sir.
All right.
Literally, Kaj is my only family here local.
Okay, then, ma'am. Sir, normally for these, I don't make these visits too intrusive. But if your mom or your sister or your brother or somebody like that was present, I will allow them to come along as a witness. I don't like third party friends. I like family. So because you know they have an iron in this fire, and third parties they don't. So again, I'm probably still looking at just giving instead of looking at allowing you to bring someone over, sir. I'm looking at doing somewhere. Doing those 6 visits and start those out on the first, third, fifth Sunday going forward until you get all 6 done, and then you'll be allowed to pick the child up and move on from there. But I'm looking at obviously right now. I'm looking at making sure the visits are okay with being at the mom's residence, or do we need a neutral site? And then at the end of when it's time to pick up and drop off, do I need to make the pick up and drop off at mom's residence, or do we need to go to Harker Heights PD or Kalina PD? So what's your input on that, sir?
I don't see a problem with coming to Ms. Brown's home to spend my visits with Kaj. I'm just a little leery because of the simple fact of, you know, what has happened,
Well, sir,
just altercation-wise between me and her, and
okay, here's
you
the
know,
deal, sir. So as soon as you get there, and I have both of y'all do the same thing, turn on those little recording devices you have in your pocket called cell phones, and you can have them run the whole 4 hours if necessary. I hate to do that, but you know, if that's what we're looking at, that level of distrust, then you just need to record the entire visit, sir. If you want to set it up on a pedestal, on a tripod with the video running, you can do that. And she gets to do the same thing.
yes, sir.
All right, so we'll get documentation of anything that goes wrong. I'm looking at going ahead and making this attempt. So if once we get to those 6 levels of that, I'll look at coming back and making a final order dealing with you and being able to pick the child up. So I'm looking at going ahead and based on the calendar, bring up my calendar. All right, this coming Sunday. It's the second Sunday of the month, so okay. I just had the first Sunday, and you got ma'am, you say you work on Saturdays, Ms. Brown?
I'm sorry. No, sir. Remember, I work for the school, so I'm off on the weekends and normally whenever the kids are off.
All right, sir, you work on Saturdays,
Yes, sir, I do.
but you're off
I'm
on
sorry.
Sunday,
Yes,
correct?
I'm sorry.
You work on Saturdays, but you're off on Sundays, correct?
Yes, sir.
All right, so what I'll go ahead and do is look, instead of making it the first Sunday of the month, I'll make it the second and fourth Sundays of the month, which means there's 2 this month. There are 3 next month, second, third, okay, second, fourth, and fifth are available next month. So you get to do the second, fourth, and fifth. So you get 3 in March. And then if you take care of the final one by the which is the second Sunday, which is the 12th of April, which means that we can start we can get something going as far as your pickup being going forward again, doing that second, fourth, and fifth Sundays of the month after that. And I'll look at bringing you guys back in on one of the general dockets on that third week of April. If there's been a missed one, then we can always factor that in. But by then, there should be somewhere between 5 and 6 done already. So let me look at the Zoom docket for that week of April and see what the general docket is. That general docket is the April the 14th, the day before the tax day. So I'll be looking at doing a reset to bring you guys back in to see how those visitations have gone and to see getting ready to switch you over to where you get to pick your child up, sir, and go off and take the child off and learn how to deal with getting ready to be 1-year-old, which is a lot of fun. So yeah, I'm kidding. It is not, but still.
He's
I'm
a
sorry,
lot of
sir.
fun right now. He's doing a lot.
Yeah, I know. It's only gonna get he's gonna get faster and better at it, okay, and smarter. So yeah, good luck with that.
Absolutely.
But anyway, that's what I'm looking at doing, folks. And again, when we come back, I can see how far y'all have gotten, and then we can do the necessary math and get you into the next level up, sir. And then, like I said, once you get to that final level and start being able to get weekends, that'll be great. And like I said, the only thing I do pare down until the child's above the age of 3. If you do everything like you're supposed to, you can get the standard visitation before the end of the year, easy. And if you do, then I would give you that standard package, but I would I would not give you the whole 30 days of the summer until the child's above the age of 3. So the summer visitation will be somewhere between a week and 2 weeks after that. But we can deal with that once we have to have a final hearing on it. So, ma'am, I'm gonna start with you. Again, I'm looking at going ahead and making this a temporary order, bringing y'all back on the 14th at 9 a.m. and get an update on how everything is going. And then we set this thing up as a final order going forward. So is there anything else you want to add or you think you need to tell the court at this point?
No, I think that's good. I agree with that.
All right, how about you, sir?
Yes, Your Honor, I'm good.
All right, then I'm gonna go ahead and set that up for those second, fourth, and fifth weekends of the month. I'm going to go ahead and reset this until April the 14th at 9 a.m. We get an update on how the temporary visits are gone, and then make a final order for you guys, so y'all can move on and get used to doing everything that you're supposed to do. So, Mr. Gwen, let's go ahead and do a temporary order and do the reset of that date. And you need anything specifically else from me to? I'm going to go ahead and make everything else as standard. Guideline child support.
Does that mean like it's like on hold or something? Like, I'm sorry, I didn't mean to interrupt. I never did a temporary, so I'm not really too sure. So we just continue to do the visits, and then we'll be back in April, right? And then it'll be finalized.
Yes, ma'am, but you'll get a court order that says all this.
Okay. Do I continue to ask Mr. Woodard for support during this time, or?
No, we're going to set up, ma'am, I hadn't finished making the order. We're going to set up temporary child support and temporary cash medical and temporary dental based on the guideline calculations of the state and all that. And once we come back for final, we'll confirm that he hadn't gotten a raise. And if he has, then we'll make that according to what his new amounts of income are. Otherwise, if it's still the same, then we'll just roll those over into a final order. You said the child's currently on Medicaid, correct?
Yes, sir.
So you'll be ordered to maintain health insurance on Medicaid or to further order the court, and he'll be ordered to reimburse you for child support, cash medical, and cash dental, and that will be the temporary, and at final the same deal, and then the visitation package will be ironed out at that time. And at that time, if everything's going smoothly and nobody's done anything that's out of the ordinary, I'll probably look at waiving court costs as far as both of you concerned. I'll automatically waive it for you, ma'am. Sir, if everything goes smooth and there's not any problems, I'll look at waiving court costs for you also. So, ma'am, any other questions? And then I'm going to come over to you, Mr. Woodard. Thank you.
No, thank you so much.
All right, Mr. Woodard, questions, sir? Questions, sir?
Yes, sir, Your Honor. So that means then that my visit days this month would be only just Sundays, correct?
Y'all can agree to anything else you want, but the court-ordered ones are on Sunday.
Okay, and then those are the 8th, the 15th, and the 22nd.
Just always look at the second and fourth Sundays of the month, And like I said, for this month, that makes it the 8th and the 15th. I mean, and the 8th and the
22nd.
22nd. Let me begin. I'm sorry, guys. I'm back in April. I gotta get back my calendar. Okay. Yeah, so for this month, it'll be the 8th and the 22nd. For March, that would be the 8th, the 22nd, and the 29th, because there's a 5th. Every now and then there's a 5th. So you get that very next weekend. So you get 2 weekends in a row. And then the next month, you go back to, in April, you go back to the second Sunday. And by then, technically, you could have done all 6. But if you haven't, then we'll finish that out and then make everything in conformity when you finally finish that up. If you finished it up, then we can do it from that date forward. Next question, sir.
When will I start paying child support, Your Honor?
Child support's going to be due the first day of March. Since we've already passed the 1st of February, you'll be due the first day of March. And Mr. Gwynn, I didn't get anything on, was there a retro request? I'm sorry, I forgot that fast.
There had been a retro request. We can hold that in abatement for the
We'll
final.
reserve retro to final. Okay, so if mom's asking for back child support for those first day, but for the up until the first day of March, sir, she's entitled to ask for that. And any funds you've given her, I can give you credit for, but we'll hold all that for final hearing. But going forward, the guideline amount that the state quoted to you earlier on child support, cash, medical, and dental, that's the amounts I'll be looking at ordering starting the first day of March. And if the state if the state has those, and you can tell those on the record again, sir, at this point what those are, please.
Thank you, Judge. State had been saving those for the closing, but that guideline child support will be $439 per month with a guideline medical of $120 per month.
Okay. And no cash medical?
That was cash.
No cash dental, no cash dental?
Oh, no cash dental, no, Judge.
All right, so those are the amounts, sir. They'll start on the first for child support and cash medical starts the first day of March and also do then again the first day of April. Next question, sir.
So if I put him on my medical, do I still pay?
You put him on the medical, bring proof of that at the final hearing, sir. What's your medical? Who's your medical with?
Right now, I receive Medicaid as well.
Okay, so you're not going to be able to take her off her grant and put him on your grant. That's not going to be possible. At least it hadn't been in the past, unless the feds change something.
Okay.
I was going to hack that as well because I never heard of cash medical, so I was wondering with that, does he can't keep his Medicaid, correct? Or would I have to like get him like maybe like a Obamacare plan?
No, ma'am, he keeps the Medicaid and the state takes the money out and gives it to the federal government.
Okay.
Okay, but he keeps, so long as he's on Medicaid, that's it. Yes, ma'am.
Okay.
All right, next question, sir.
So let me see. And then the calculations from the state, those aren't based off of like any of my bills or anything like that at all.
No, sir, it's based on the fact that you make $15 an hour, you work full time, at 15 and some change, and the state has calculated the child support and cash medical based on those amounts. And you have no other children.
And then if I send in my itemized list, will that amount change any or no, sir?
No, sir. If you want to deviate from what's called guideline child support, you have to give me a legal reason to do so. We don't look at your expenses because your expenses can be super high or super low, but we just put them in. The legislature said this is what the amount should be for someone who earns what you earn. If you want something different, you need to give the court a legal reason to do something different.
Yes, sir.
Any other questions, Mr. Woodard?
No, sir.
All right, everybody, I'm going to have the state prepare that temporary order and do the reset for the April date, and we'll come in with the update and finish this one up. All right, anything else, Ms. Brown?
No, thank you, guys.
All right, if you have any questions about the order, the state's going to send you a copy of the order. It's written by lawyers. It looks like it's written by lawyers. It's going to be 20-something pages long. So, it's got a lot of stuff in it. But if you, state will be happy to ask questions. But if you need legal advice, either you have the absolute right to take your that order and go and get a consult, or hire a lawyer to take a look at it and go forward. But for right now, this is everything. If you brought in the dream team to come do this case, they probably wouldn't have gotten anything else different and than you get today, and you would be out tens of thousands of dollars. Okay, so yeah. So all right. So Mr. Woodard, any final questions, sir?
No, sir, but if I'm hearing correctly, that would be paying then $559 a month, correct?
The amounts together, you added them both together, that comes out to $559. I didn't do the math, sir. That would be correct. And again, it's due on the first day of the month, and it's not paid by the last day of the month. You're in violation of the court order. And the state's eventually going to send out a wage withholding order, and it automatically start taking out of your paycheck.
Oh, okay. So that's what I'm asking is basically do they
Until
take
you
it
see
all
it
at
coming
once?
out, you got to pay it, sir. And the information on how to pay it and where to pay it is in the order. And if you lose that or can't figure it out, just show up at Walmart or CVS Pharmacy, say, hey, I want to pay my child support by MoneyGram, Western Union. They'll charge you a couple of dollars, and you give them the OAG number that's right beneath y'all's name, not the cause number from Bell County, but the OAG number. They'll plug that in. You give them the money. They send it over electronically to mama.
Okay, so I have to pay that $559 and one WAP at the beginning of every month? Or
No,
they
sir.
start
You can do it. You can do it in payments, but so long as by the end of the month, it's paid in full. How often do you get paid?
I get paid every week, sir.
Divided by well, if you divide it by 4, you'll finish ahead. You'll finish a few dollars ahead. So every week, go ahead and pay 1/4 of it, and you'll be fine.
Okay, that'll work.
All right. All right, Mr. Gwynn. Anything else at this time, sir?
Just to verify, for the purposes of this temporary order, I just need to set the 6 initial visits, the second, fourth, fifth Sunday, 1 p.m. to 5 p.m. supervised by mom.
Correct.
And we're coming back on April 14th at 9 a.m. with everything granted as the guideline. Cool. Got it.
All right, then. All right, see everybody the day before tax day. I'll be in a good mood. So yeah, we'll see. Anyway, I'll see everybody then. And again, if y'all have any questions, you can run them by the state. If you have any if you got any legal advice needed, then you do need to go see your own counsel. Anyway, I'll see everybody in April, and we're off the record. Thank you.
Oh, real quick, Your Honor.
Yes, sir.
Am I able to file him on my taxes or no?
No. I'm sorry, I didn't mean to put it like that. Believe me, I've heard that about 15,000 times as a lawyer and more since I've been a judge. I have no purview over the Internal Revenue Service of the United States of America. They say that the tax deduction goes to the custodial parent, and no state judge has the power to change that. And no federal judge is going to do it. So I'm sorry about that one, sir. That's just federal law. Anything else? Okay. Anything else, sir?
It must just depend on the state then.
I'm sorry?
I said it must just depend on the state then.
No, sir, it does not depend on the state. The federal government controls who gets the income tax deduction, not the state, not any of the 50 states. And the law is the federal government has decided that goes to the custodial parent.
Yes, sir.
Yeah, believe me, that's been the way it's been since I've been a lawyer, and that's the way it's going to be long after I'm gone, probably. So yeah. All right, thank y'all both very much, and I'll let the state start preparing that order. Are the parties excused, Mr. Gwynn, or they go back and break out and wait for you to send them over a copy?
They are excused at this time. I will have a copy to them in their email via DocuSign by the end of the business day, barring any unforeseen circumstances.
All right, folks, you're gonna get a copy of the order and sign off on it. If you sign off on it, doesn't mean you agree to it, but if you don't sign off on it, eventually it'll be sent to me. And so long as it's everything I ruled on here today, then I'll sign off on it, and that'll be your temporary order going forward. And at the final hearing, if we need to tweak it and change things around, we can. But for right now, this is what this will control until we come back in April. Thank you both very much, and thank you, Mr. Gwynn. We're off the record.
Thank you, guys. Bye-bye.
Thank you.
Well, Judge, speaking with the parties, it appears that at this point, both parties are in agreement with the numbers as they exist at the time of that CSRP. However, the state's of the understanding that one of the parties wanted to ask the court for some form of DNA testing in spite of this being a modification of an almost 4-year-old order.
Okay. And which party is making that request, please?
I believe that would be Mr. Waite.
All right, Mr. Waite, here's the thing, sir. Let me go back at the original order of this one. Let's see, there appears to be an original order, a child support review order that was signed off on by this court back on 5/16/22. I'm sorry, it was signed off on by the parties in agreement in 5/16/22, along with the court finding and making a finding of paternity on 5/19/22. Mr. Waite, this matter is what the law calls res judicata. There is a final order that's more than 30 that was signed more than 30 days ago that made findings of paternity. No one in this county has the authority to set that aside. Maybe the Supreme Court of the state of Texas could, but I'm not even, based on that information, I don't think the Court of Appeals could. So the bottom line is that matter has been long litigated and taken care of, sir. And like I said, that order is final, and as far as that order is concerned, sir, the attorney has been established. You might need, if you want to do something differently, you can go talk to an attorney. But your remedies are very, very limited at this point because there is a final order of paternity in this case. So at this time, with that on the record, I'll allow the state to proceed, and we'll see and tell the court what the agreements and non-agreements are as per the current order dealing with child support going forward. Thank you.
Thank you, Judge. Suppose at this time state would like to call Alia Brazelton.
I'm here.
All right, so at this time, I'll ask both parties to raise your right hands, and I'll swear both of y'all in at the same time. So at this time, if both Ms. Brazelton and Mr. Waite both solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you.
I
do.
swear.
Sure.
All right, you're both officially on the oath, and I'll allow the state to proceed asking you questions. That you can put your hand down, ma'am. If there and of course, at the end of the hearing, if there's anything either of you want to add that didn't come out during the state's questioning, so long as it's relevant to what we're doing here, the court will allow you to bring that information up. So you may proceed at this time, Mr. Gwynn. Thank you.
Thank you. And real quick, actually, the state would like to go back and run the numbers in the CSRP as just to streamline this a bit. So the new non-taxable gross income of the non-custodial parent would be found to be $4,412.76, setting a guideline child support of $651. The child is currently on the non-custodial parent's insurance, and at the time of the CSRP, so as of the 31st of December of 2025, the non-custodial parent was in future pay of $26.45. The state is of the understanding that both parties agree that all of the above is factual and correct.
All right,
So-
you can go ahead and call your witnesses, sir, and then we'll get Mr. Waite to and Ms. Brazelton to confirm or deny. Thank you.
Thank you. State would like to call Ms. Brazelton.
All right, ma'am, state your full name, please.
Alia Monet Brazelton.
All right, thank you. You may proceed, Mr. Gwynn.
And what is the name of the child or children that we're here on?
Noah Dewan Waits.
And how old is Noah?
He'll be 4 on the 17th of this month.
And did you hear what the state told the court as far as the agreements were with regard to that CSRP that occurred last year?
Yes, that it would be Mr. Waits would still be responsible for health insurance, and that the new amount would be $651.
And you're in agreement with all of that?
Yes.
Okay. No further questions at this time, Judge.
All right, ma'am, be back in just a moment. Call your next witness, please.
State would like to call Rodney Waite.
Yes.
All right, sir, state your full name for the record.
My name is Rodney Waite.
Thank you very much. You may proceed.
Mr. Waite, were you able to hear the state when the state reflected to the court what those numbers were from that CSRP that occurred?
Yes.
And you're in agreement with that those are the correct numbers?
Yes, but the only thing with the insurance, no longer accept the affidavit and sign first and last name for the child and the father on the birth certificate.
I'm sorry, so you cracked up on me. What was that? What was that comment?
Yes, for with the VA, they no longer accept the affidavit. They need to actually have a signature for the birth certificate, which is the first and last name of the father, and also with the child as well. And that's the reason why I was actually requesting for the as of course I couldn't actually do it at that time. The reason why 30 days elapsed because I was overseas at that time.
All right, sir. Okay. The court. I'm not getting. The court order found that you are the father. That court order could be used to. This is a state of Texas case, so that a court order could be used to put everybody properly on the birth certificate. Are you saying the birth certificate doesn't reflect that you're the father at this time?
I actually didn't even have a birth certificate that was signed. Your Honor. It was at that time frame because during COVID, I think it was like a signature that we did over the online because I was overseas.
Okay.
Um,
Sir, a birth certificate is not done
Right.
by the court. A birth certificate is done by the Bureau of Biostatistics in Austin, Texas. So they would issue a certified birth certificate, and I think Mom has one. Is that correct, ma'am?
Yes, and I have a signature of the authorization of paternity with a signature right here from, it's dated February 18th of 2022, and it's a wet signature. This is an authorization of paternity.
All right.
Let
So
me
if you want to
unblur
make a copy of that, give that to the father. That should that should suffice everything, sir. But of course, sir, you have the opportunity to go ahead and get your own copy from the Bureau of Biostatistics. All you gotta do is go online and give the state of Texas some money, and they'll send you whatever you need. Well, they'll send you what they can, but they'll send you your own copy and verify that it is a true and correct copy.
well, I understand that, Your Honor, but they say they actually need the full actual birth certificate, not the paternity test or the fraternity signature
That's
authorization.
what I'm saying, sir. You can get a copy of the full birth certificate from the Bureau of Biostatistics.
I understand, Your Honor.
So there again, the court order controls, but again, the Army's the Army. I had trial care until my last year of law school, so yeah, I know how the Army does things. So yeah. Anyway, you may proceed with the next question, Mr. Gwen.
State does not believe it has any further questions of this witness at this time, Judge.
All right, sir. Now, since you can get a copy of the birth certificate that actually shows that you're the father, and now that's all online. Back in the good old days, you'd have to wait weeks, and it probably doesn't take that long. You might be able to get it instantaneously these days. I haven't tried to get one in a while. Is there anything else you're asking the court to do here today? Because again, the guideline's the guideline. Is there anything else you're asking the court to do here today above and beyond what the state is requesting as far and what I understand your agreements to be?
Just pretty much just for us with the DNA test, Your Honor. I understand about what you were saying for us is 30 days overlap, and I also understand that in the case that if I actually did have an attorney, which I have to do at my own expense, and for us is actually moving forward to do what I need to do to keep my balance up to par during that time frame. But that's the only thing that actually is suggested and requested.
All right, sir. I'm sorry, I lost you on that one. I understand. I cannot order a DNA test,
Mm-hmm.
and there's already a court order that gets your birth certificate set up. There's a modification of child support based on what your current income is, and the state wishes to start that on what date, Mr. Gwynn?
I'm sorry, Judge.
Start date.
Let me pull it up.
What's the CSRO say? I mean, the non-agreed to child support review order say? What's the start date on the new child support amount?
February
I'm
1st.
looking right now.
Okay, so it starts the 1st of February, and so that's this month. So that's that's well within the loop there. So that's what the court would that's what the court would order. So based on those circumstances, sir, what else are you asking the court to do here today?
Just pretty much that was just my suggestion there, but I'll go ahead and actually consult with an attorney moving forward. But appreciate it.
All right, then, sir. But again, the court is going to go ahead and sign off on the order. So this is will be coming to order the court. And obviously, you can do what you necessary, and you can always get a copy of that birth certificate for yourself. The child was actually born in which county, ma'am?
Bell County.
And sir, where are you located right now?
I live in Coryell County in Coppers Cove.
Where do you live, sir?
Yes, I live in Passes.
Yeah. Passes?
Yes. Yes, Your Honor.
All right, so sir, either one of you could actually go down to the county clerk's office in Bell County instead of going all the way down to Bureau of Vital Statistics. Walk in with your money and get a copy of the birth certificate directly from the county.
Yeah, I think all you need is a Texas driver's license because his name's on the birth certificate. So you will, as long as he has a Texas license,
You don't have to have ID because they're not going to turn. No, they're not going to turn a birth certificate over to you without proper ID. But yeah, you can actually get it done. In fact, that's what I had to do to get my driver's license renewed a couple of years ago. So yeah, go get a copy of my birth certificate. Yeah. All right, any other questions, sir?
No, Your Honor.
All right, folks, I'll go ahead and let the state prepare that order and send that one over for me by DocuSign. Do you? Mom's already signed off on it, sir. You don't have to sign off unless you want to. Do you wish to sign off on the order at this time, sir, or you just want to forward it to the court?
I just forward to the court, Your Honor.
All right, then, Mr. Gwynn, just send that one over as is with mom's signature by DocuSign and send CC Dad, send him a copy, give him an opportunity to do it. But go ahead and send it over to me for my final signature. All right, thank you. Anything else, Mr. Gwynn?
There's not at this time, Judge.
Ms. Brazelton, any questions, ma'am? I see you got your finger up, so yes, ma'am.
Yes, sorry. I just in the current CS order or the CSR review, it's there's a court ordered income withholding because I believe when Mr. Waite got out of the military, we don't communicate, me and Mr. Waite, but when he got out of the military in September 2024, that's when I started to see net negligence in the consistent child support payment. And so even now he's behind. There's a new balance of $737. And so I'm just wondering how to ensure that.
You can talk to Mr. Gwynn about that, ma'am, but right now that's beyond my purview. Right now, obviously a wage withholding order to go out. Sir, what's your current status? Are you getting VA, or are you still in the military? You sound like you're out of the military. You retired. What are we looking at, sir?
No, I'm actually medical discharge, and actually I'm still working on that with the VA. Luckily, I am in school, so the money is actually coming in for us with my school, post refunds and everything. That's how I'm able to make my payments. Actually, caught up with my payments too as well.
All right, and sir, going forward, and you're not getting a VA disability this time?
I'm still in the process of it because I have one more claim. They still actually trying to make a decision on.
And you're definitely not getting anything through DFAS, correct?
No.
All right, then, sir, here's the deal. Going forward, you have to, until you actually get a new employment or get officially retired by the Army or something like that, which I doubt, but anything going forward is your responsibility to pay the child support, and it's due and owed on, and you say you made it up, that's great. But going forward, make sure the new amount is paid only before the last day of each month. Otherwise, the state will have the right to come in and do what's called a motion for enforcement, which means they'll come in and get a judgment against you, make you pay some court costs and attorney fees, so it's just not worth it. So go ahead and make sure going forward that the new amount is always paid and paid in full only before the last day of each month. Understood?
Yes, Your Honor.
All right, then. All right, ma'am, and again, if you have any questions or anything you want to go over with the state, again, what you're asking is actually beyond what the day's hearing is for, and you can see what your options are if you want to discuss that with them, ma'am. Anything else?
I could speak to Ms. Brazelton in the breakout room after this.
All right, then. So anything else, Ms. Brazelton?
No, sir.
Anything else, Mr. Waite?
No, Your Honor.
All right, thank you both very much. Good luck to you. Thank you for your service, sir. Thank you, ma'am, for being there. As always, as a mom, are you in the military also, or retired? No. Okay, no, not a problem. Believe me, I'm not either. Anyway, so that was Dad. That wasn't me. All right, so thank you. Anyway, thank y'all, and I'll go ahead and let the state prepare that order, and I'll sign off once I get it. We're off the record, and everybody be safe out there. Thank you.
You as well. Thank you.
Your Honor, we're here today based on a capias the court had issued on October the 24th. Mr. Holly was picked up and assessed a bond of $5,000. He made payment on that on December the 10th, and we're now asking the court to approve an order to release these funds that they might be dispersed to Ms. Johnson to partially liquidate the arrearages owed by Mr. Riley, or Mr. Holly, rather.
Okay. So the amount owed is obviously in excess of the 5,000 that's currently on deposit with the district clerk, correct?
Yes, sir. $11,000 is approximately the balance as of today, and I'm sure will be reduced after these monies are dispersed.
Okay. And Ms. Johnson, I'm pretty sure you're in agreement with being release those funds, correct, ma'am?
Yes, sir. Thank you.
All right, granted. Now,
Thank
obviously, if the money's owed you, ma'am, I'll go ahead and grant and let the state do what they got to do to try to collect the rest of those funds for you. Is there anything else at this time, Mr. Coates?
Nothing further, Your Honor.
All right, like I said again, when the court took judicial notice of the information provided in the court file, the court will note that the money is owed to Ms. Johnson. I will grant her release, and hopefully, ma'am, you'll get that as soon as possible. But you know, bureaucracy. But right now, those funds are yours, and they are officially released once I get the order, and I'll sign off on it immediately, ma'am.
Thank
May
you.
Ms. Johnson be excused, Mr. Coates.
Yes, sir.
All right, ma'am, you're free to go. Have a happy New Year and be safe out there, and hopefully no more winter. Okay, I'm good.
Thank you.
Thank you, ma'am.
And Mr. Holly, you're free to go as well.
All right, thank you. Thank you, Mr.
Thank
Holly.
you.
I'm sorry, Mr.
Thank
Holly, I
you.
didn't see you sitting down there. Sir, do you have any questions?
No, no, sir.
All right, good enough then, sir. I'm granting that, and everybody's free to go. Thank you. So I
Thanks, sir.
apologize. I didn't see you down there. Thank you.
And thank you.
All right, we're off the record.
Thank you, Judge.
So we originally filed a petition to establish a parent-child relationship on a child named Waylon Nunley, born in 2021. We realized subsequently that there were two other children between Miss Love, the mother, and Mr. Nunley, the father, that had been handled in a different case, and that's why I got consolidated to include all three children. And we filed a new a first amended petition, basically asking to set support and modify for all three. So I understand that first amended was served on to everyone. There's the problem, Your Honor, we're facing is that part of what we do is to confirm arrears, because there was a order in district court that was signed back in I believe June 2025. No, sir, July 10th, 2025. Hearing was in June. That set support regarding the two older ones. And the two older ones are Hayden and Brody. Support against Mr. Nunley in favor of Miss Love. With Miss Cepillo, who is the grandmother. She was also she was a non-parent possessory. The state does not have that order in our system, Your Honor. We don't have any financial information, basically, that I can give to you. And so the state is asking the court to do a short reset. You know, it won't take long to get this entered once I tell them to do it. So I think, you know, state is asking for a special. And I think the rest of this case would be easily enough done. So basically the state just does not want to finalize today. I prefer a short reset, but at worst, Your Honor, a temporary order that does not resolve the issue of the arrears and retro yet. Current support would obviously, Your Honor, be zero. State understand he's going to be there for a while. His pre-trial hearing in his criminal matters is at the end of February. So I don't think there's any dispute on that. So basically, Your Honor, just asking for the reset, and if I can't do that, then the temporary order. I understand Mr. Rimhall wants to get everything finalized. His position is that he can calculate the arrears himself, and while the state is grateful, the problem, Your Honor, is that if we have a tried and tested method of calculating arrears, of getting orders entered and doing that, and it's worked for a lot of cases, Your Honor, and if it turns out that what judgment he takes is different than what we come up with in our system, then, you know, once we get this order entered, that district court order entered, then the state might have to come back and that would waste even more time. So, you know, to prevent all that, like I said, preferably reset, if not temp.
How fast the time? How long time are you looking at there, Mr. Welch? You says it won't take a long time. Are you looking 30 days, 60 days, 75 days? What are we talking about?
I mean, to get the order, I mean, I would say no more than 30.
Okay. All right, then. Thank you. Anything else on your opening, sir?
I think, Your Honor, if you do go forward with something temporary, I can tell you on the issues that I don't really have an interest. I think Mr. Brimall was looking at continuing the no physical access, no orders regarding physical possession because he's in jail. And there's also, I believe, some family violence issues. And I believe Mr. Brimall was going to ask for non-disclosure and a family violence finding too. The family violence finding was kind of mentioned in the last district court order with the 2 older children. Whether they did it correctly, Your Honor, I think I can leave that to Mr. Brimhall to talk more. But I think that's. Oh, and there's also DNA results, Your Honor. We filed them with the court. If you are going to go forward, I can get those submitted as an exhibit. But we'll see. And that's it, Your Honor.
All right, Mr. Brimall.
So my posture on this case is the following.
06758.
Hold on, someone. What's that in the background?
Maybe that's Mr. Nunley's. Someone with Mr. Nunley.
Okay.
I think
Yeah,
okay.
the deputy, yeah. So
Okay. So my position on this. My position on this case is that
Thank you.
as
Your Honor,
to
I can mute him. Or
there you go. Okay, yeah, I was gonna say yeah. All right. My position is this. We've been reset several times. One of them was to consolidate this case with the district court action regarding the older 2 children. The court previously did consolidate the 2 cases together. On the arrears situation, the state, they did not enter that order from last year under their system. But the amounts that were ordered, $289 for child support, $50 for medical, and $10 for dental. I mean, I believe the testimony will be that Mr. Nunley has not paid either of those 3 obligations for the entirety of the time that obligation has been in effect, which is a total of 14 months as of the end of last month, 1/31. So regarding the math on it, I mean, we're doing 289 times 14 and then doing math on the accrued interest. And I have an amount proposed on that. I mean, for example, on the child support, I think his accumulated arrears as of right now, the principal would be $4,046, and the accrued interest on those arrears over that exact time period would be $151.73. So, like, my request on the child support judgment would be $41.97.73, and then I have numbers for medical and dental as well. On the issue of retroactive support for Wayland, which can be added to the arrears that are in place for the other 2, I think a cumulative judgment adding both the arrears and the retro for the 3rd child is appropriate in this case. I have a proposal on what I believe the retro for the 3rd child would be. It's based on a minimum wage calculation over the period of from birth to the time of Mr. Nunley's incarceration. I'm happy to go into the details of that as well. But I do have proposed. Sorry, I'm losing my voice or something there. But I do have proposed judgment amounts for child medical and dental. Current support should be set to 0 based on Mr. Nunley's incarceration status as of I would say this month, 2/1, as of 2/1. And then regarding conservatorship, the prior order, I'm not asking for any change from the prior order regarding the conservatorship situation. The mother should continue to be the sole managing for all three. The father, Mr. Nunley, was not given any designation by the district court, so I'm not requesting any change to that. The grandmother, Miss Sapio, was named a non-parent PC, but it's my understanding after consulting with her that she would like to be removed from the case completely as a conservator. And just, obviously she's still a grandma, but she doesn't want to have to keep coming to court on these kind of things. And so she wants to be released from the case. The district court did well, at least the order that got signed by the district court, I'll say that it's somewhat ambiguous as to a couple of things, but it does allude to a family violence finding being made by the district court, so I would like that to continue. It specifically says that there was one made, but it doesn't actually list the finding itself. So I would like the finding of family violence in the past to continue. I would like non-disclosure to continue. And then regarding the issue of possession and access, the only visits the district court gave Mr. Nunley for the two older children were discretionary electronic visits. Discretionary by the mother. Essentially, if she answered, that would be fine. If she did not, that would also be fine, depending on what's going on. So I'm not asking for a change to any of that. I want the district court order to basically remain the same as to conservatorship, with the only change being that Miss Sapio can be removed. And then as to the visitation, I'm not asking for a change to that either. And then the support just being changed to 0 due to the incarceration status. So, well, I understand the state's position. I think we can knock it out today at a final hearing. I don't know that we need to have more time. If the court does grant the state an additional time period to calculate what the current arrears are, my understanding is that the jail has specific times when they can have inmates appear by Zoom, and I can provide those to the court so that we can have the court schedule a special setting during a time when the jail can make Mr. Nunley available.
All right then. Anything else on response, Mr. Welch?
Your Honor, just to make it clear, Your Honor, even if it's a small, deviation between what
Yeah,
we
I know,
can.
Mr. Welch. I know about y'all's calculator, and it's not. Y'all, for some strange reason, the state of Texas hates Microsoft Excel in its pure form. I'm not sure what y'all using these days, but I get it, sir. It could be a couple of dollars off. It could be $10 off. It could be 8 cents off. But I understand what you're requesting, sir. Anything else in addition to that, though?
I should just make this clear, Your Honor. We don't lightly want to reset cases.
Oh yeah.
We want this case to be done almost as much as Mr. Brimhall. We just want to make sure we get it done right.
Yeah. Well, at this time, Mr. Brimhall, I'm looking at going ahead and doing this as a special. Let's do it one final time. Let me know what the dates are that he could appear via Zoom. We can do it in an afternoon setting based on your schedule and the state schedule. And obviously, if he's got there's some testimony, there's some information that he's actually he's still in the pretrial stage of his circumstances. So there's okay, so that the next pretrial is at the end of the month.
I believe
Yes,
that's
Your
correct,
Honor.
Judge.
And who's his lawyer on that? Do you know?
I can find that out.
I believe it is I believe it's Mr. Joe Weiner.
Okay, it's Joe. All right, thank you.
If I'm not,
Oh yeah.
I believe that's right. I'm not sure if it's the same. There's two different felonies. I'm assuming it's the same attorney for both, but sometimes they don't do that.
Your Honor,
All right,
I'm on Odyssey now. I can check it now.
Well, okay, it doesn't matter, but I'm looking at going ahead and let's doing this as a special. I've got
So, Judge, the days that the jail, I guess the jail has different parameters. So this is what they gave me. They said that they can have individuals appear by Zoom. Mondays after 10 o'clock, Tuesdays between 9 and 2, and Wednesdays after 11 o'clock.
Okay,
So those are
right
kind
now, it
of,
looks like I got every Monday in March available except the second Monday, which is Comanche. So we can set this for a 10 o'clock hearing on any Monday in March after at 10 o'clock or at 10:30 if it helps the jail make sure that's something not running late. And we can set this for a final hearing at 10:30 where they're the only case I have on
Okay.
any Monday in March except for the like a second Monday, which again is Comanche.
the 16th works for me if it works for everybody else.
Not the 16th.
Oh, sorry.
Is that spring break week?
Yes, Your Honor.
Okay,
Okay,
never
that's
mind.
spring
Never
break week.
mind.
Everybody's gone, so.
Never mind. Maybe if the state can get it done by the 2nd, I'm available on the 2nd, but that would be a less than 30-day turnaround for them.
Well, yeah, because this is a month with only 28 days in it, so but it's 4 weeks. Can you be ready on the 2nd, or do we need to look at the 23rd?
The 23rd is fine as well, Judge, with me.
Your Honor, I can't. I wish I could give you an exact timeline. I mean, typically order entry takes like a day, but this case we're gonna have to add some. We're gonna have to do a few special things.
Let's just go and look at the 23rd. That way we don't have to. So either the 23rd or the 30th are the 2 dates I'm looking at. So let's see what the parties, Ms. Love and Ms. Capillo are looking at as far as being okay with. So I got 23rd at 10:30 a.m. and I got the 30th at 10:30 a.m. And you're the only case I have at that time, and obviously Mr. Nunley can appear from jail at that point. So Ms. Love, is there a problem with the either the like I said, the 23rd of March or the 30th of March at 10:30 a.m. now?
No.
All right, and Ms. Capillo, obviously you don't have to appear, ma'am, but I'm looking at those dates and you can appear on those dates. Is there a problem with either of those Mondays, ma'am?
No, sir.
All right, then well, let's go for the earlier possible. Mr. Nunley, obviously that works for the jail schedule. So, and hopefully by then we'll have some input on what your final disposition of your case may be. If you got a pretrial in late in February, if you decide to do something with the prosecutor's office, then obviously we can take that into consideration too. But otherwise, we'll just look at ordering zero child support going forward and do that appropriately, and having you appear at the hearing on the 23rd at 10:30 a.m. So is there anything else you want to add, sir?
I think he needs to be unmuted. Or I don't know if he can he unmute himself?
I don't know if you can. Yeah.
No, that's fine. Thank you. I did.
All right then. All right then, Mr. Wells, let's do a reset date to the 23rd of March at 10:30 a.m. and we'll rock and roll.
Yes, Your Honor. Since Mr. Nunley can't sign the reset, we'll probably just do a notice of hearing for 10:30 a.m. March 23rd. Will you be creating a new Zoom code for this?
Getting ready to do it as soon as we finish the hearing, sir.
And then as for Miss Apio, the grandmother, well, we'll send it to her. We'll send the notice of hearing to her.
She's still a necessary party, so if she doesn't want, if she wants to be left out at the final order, that'll be fine. Just get her testimony on that, and we'll take care of that also. All right.
Yes, Your Honor.
Thank you, Judge.
All right, thank you, everybody. Be safe out there, and thank you, and apologize for any time you had to wait. We're off the record for now, and I'll see everybody in March. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, so both parties are present. The one who is not present is Mr. Maldonado Perez, the guardian attorney ad litem for the children. So, I mean, the state is so. The issue, Your Honor, is that when you made your rulings back in November 21st, 2025, you gave Mr. Escobedo some supervised visitation basically at a center. I put in my notes, it was called Access Supervised Services Visitor Center on I-35. But you had asked Mr. Maldonado to basically do some research and confirm that the facility is still working, things like that.
Right.
Problem, Your Honor, is that I have not heard anything back from Mr. Maldonado about this. And so I tried looking up this center on my own, and while I do see it as a place,
You know, that's I saw it online myself. That's where I got it from. But again, that doesn't mean it's you know, sometimes those websites are still up and running long after everybody's long gone. So
indeed, Your Honor. And so I saw it as a place, but I don't know where it's at. I don't know if I can't find any more information. So, Your Honor, I put in the order because that's what you'd wanted originally. Put in the order, and I was hoping he would come so that he could tell me, like, you know, if that's. I have no interest in this matter, Your Honor, but I do have an interest in getting an order that's, you know, compliant with what you want.
that's in the order from February. I'm sorry, from November, because it looked like we had a hearing back on 21 November of last year, and so that was the new order was to set that up, correct?
Yes, Your Honor. Yeah, the final rulings, November 21st, 2025. Yes, that's when you made your ruling on that. And yeah, Your Honor, that's why you don't see any other signatures, is because I knew it was going to change probably once Mr. Maldonado told me that info. So I figured, why send it to the parties then? So, I mean, regarding this, what the state's interested in, Your Honor, the support, you know, insurance, things like that, that's all good to go on the order. But Your Honor, it's just.
All right.
It's
Well,
just
it
that
sounds like what you
facility.
got to do is go ahead and file a motion to enter that order as is. I'll try to do my own. I got a couple of colleagues that are down in the Austin area. This is not the places. This was the location of this facility was where again, please? I don't remember where it was at this time because I've looked up so many of these.
Well, I guess two things, Your Honor. First, the location. The only notes I have are that it's on I-35.
Okay.
That's kind of one of the things I was hoping Mr. Maldonado could tell me. And then we filed our motion for entry of it.
Right.
So, like I said, worst case scenario, it does have everything the state is requesting. So it is, you know, it is good enough for that. It's just, like I said, I understand the court wanted something, and so I was just hoping the court could, you know, like decide a place, and then I could put it in there, and then.
Well, let's go ahead and keep the place that's in there because that's what I originally ruled on. And hopefully, if Mr. Maldonado finds there's something wrong with that place, we can do a. You know, I got 30 days after I signed the order to, you know, get that updated. But if it's and I think I looked it up originally because again, I've been looking at a lot of these recently, and some are certified and some are used by CPS as their center. And I don't remember this one in particular. But my understanding it was you know, it was certified as being, you know, being that type of center and meets all the requirements of such. Excuse me. So anyway, I'm probably looking at if the motion is before the court, I'm looking at going ahead and doing that and signing off on it. And then I can say that if Mr. Maldonado finds there's something wrong with that, or somebody else finds out there's something wrong with that, then we can go ahead and do a motion for further orders, or a motion to set that aside, or a motion to modify that particular item. But for right now, if I'm looking at going ahead and just making that part of the order because that's what I did order.
Understood, Your Honor. And that'll work for us. He'll be released after 30 days, but that 30 days should give him plenty of time to.
Yeah, to dot his I's and dot his T's, because I know it's not like him. You know, the gentleman always shows up, and in fact, I know he was just here on a couple of hearings, at least one hearing back in Zoom. I'm sorry.
Thursdays are his days to appear. So
okay, that may be the problem. Yeah, that's right. Because I know last time he was here already this year, so I know he shows up. So I tell you what, let's go ahead and do it this time, this way. And if he And of course, if we hear from him on my own motion, I can reset this thing up for a hearing on a Thursday that I know he can appear. Otherwise, let's just go ahead and do it as is at this point, then, Mr. Welch, and give him that 30 days to double check everything. Okay.
Yes, Your Honor.
All right. So if does either party does either party have something else they want to add to this information, or anything else they're requesting the court to do here as far as entering Mr. Welch's order at this time? And I'll start with you, Ms. Cantu, and then go to Mr. Escobedo.
You're muted, ma'am.
No.
All right, Mr. Escobedo, anything else, sir?
Just all I want is the actual physical address of that place because I cannot find it.
All right, Mr. Welch, do we have the physical address on it? It should be right there.
I don't, Your Honor. I can't find it. I know
Right, tell you what, guys, I'm going to go ahead and y'all don't have to appear, but I'm going to find out this is correct. I'm going to reset this matter for a Thursday docket, and I'll double check this myself. Like I said, I got a couple of state people in all people who can tell me if this is what they're doing, because yeah, the judge used to be a CPS lawyer back in the day, so I can still find that information out and confirm that this place is certified, and I'll confirm that as a problem. If there's I'll confirm that if there's a problem, I will on my own motion fix it and set that for a proper hearing. But for right now, let's go ahead and leave it in there, and I will reset this matter for entry of order on a Thursday docket. Because again, yeah, Mr. Malo Perez is a Thursday. I forgot about that. So here we go. So Mr. Welch, I want to give at least 3 days notice. So we are, what's the next Thursday that I have? That's not, okay, I'm in March now. Let me come out of there. You know, the dates are going to be the exact same thing for February and March going forward. So, all right, so this coming Thursday is a special setting Thursday. I'm gonna go ahead and reset this on the general docket on the 12th, Mr. Welch, and that way I'll give that way if Mr. Maldonado Perez wants to appear, we got more than 3 days notice, and that's one of the days he can appear. But neither Ms. Cantu or Mr. Escobedo need to appear unless they want to. But by then, between the three of us, I'm pretty sure we're going to find out exactly what facility we'll use going forward, because I know Travis County's always had these type of facilities since the 90s. So yeah. So I'm assuming that, yeah, we'll go ahead and set that up, but I'll confirm that, and we'll reset this matter for the Thursday the 12th at 9 a.m. And again, Ms. Cantu and Mr. Escobedo, y'all don't have to appear. Y'all go to work, do what y'all need to take care of your lives. But I will go ahead and make sure that there's a formal notice sent to you what the it'll be in the order, and I'll have Mr. Maldonado Perez also send you update as far as that information is concerned to confirm that's what we're using. So again, Ms. Cantu, any questions?
No.
Okay, Mr. Escobedo.
No, that's what I need.
All right, then, folks. Again, Mr. Welch, let's go ahead and, like I said, reset to the 12th, and send Mr. Maldonado Perez notice, and we'll rock this one out on that date. Okay.
Yes, Your Honor. Yeah, we'll do. The state will issue a notice of hearing, and he'll get an e-filed on that,
Yeah.
And
in the interim, I'm gonna go ahead and see what I can find out from my contacts in all, in Travis and in Williamson County. Thank you.
Thank you, Your Honor.
But I'll give Judge Barson a call on that one too. So yeah, I'll go straight to the source. All right, thank you. All right, is everybody's free to go at this time?
I would like them to just briefly hang around just to confirm their contact information.
All right, folks. Mr. Welch is going to put you back in breakout room. Confirm your contact information off Zoom, or off of YouTube, and that way, and then y'all free to go after that. Everybody be safe out there, and if you want to be, I'll see you next week. If you don't worry about it. Thank you.
Thank you, Your Honor. Everyone's present, including Mr. Maldonado. State and Mr. Maldonado talked, and he does say understands that he does want some more time. So I believe he said that he can't make the February 12th.
Okay.
Your Honor.
All right, so the next Thursday I have available after the 12th, sir, would be Well, obviously I can do something on, let's see. Oh, that's land passes. Never mind. Oh, that's a
If I
special.
may, Your Honor.
Let's see. I got
If I may, Your Honor.
yes, sir.
Yes. The institution you suggested is called Family Access Services. Is no longer in business.
Okay. All right then. That's why I was gonna double check because these things come and go. So yeah, all right. All right, because I didn't call them, I just looked up their website and obviously that's still there. All right then. I tell you what, let's look at doing a reset to, because I'm gonna go ahead and call. I'll check in with my CPS counterparts, associate judges, to see if they know any, if they have a facility that they like using down in the Travis County area, and I also could check with the CPS associate judges down there to see who they like to use. And let's see a date that's at least a week or let's get something we get to a final order before the end of this month, so everything can start for the 1st of March. So the 12th is the 12th is not good for you, sir.
Your Honor, I'm good on the 19th and the following week.
Oh, okay. All right, I may set this up as a special setting then. Let's see, I've got a special setting at 9:30. And I got a special setting at 1:30. Tell you what, since this is going to be a real short one, I can set up a special setting at 1 p.m. on the 19th, where we're the only, that's the only case I have. Can you do it can you do 1 p.m., Mr. Perez?
Yes, Your Honor.
How about you, Ms. Cantu? A 30-minute hearing at best, and you're the only case I have, and you just show up at 1 and we'll get it done. Does that work for you on the 19th, ma'am?
Yes.
All right, Mr. Escobedo, how about you, sir?
Yes, sir.
All right, then let's go ahead and I'll go ahead and do a special setting, Mr. Welch, and reset that for 1 p.m. on that day. Then we can run it. If we run a little late, that's not a problem, but I'll go ahead and set it at 1 p.m. And hopefully, like by then, I can get some feedback from my judges and ad litem's that have used the Travis County facilities for such. All right. All right. All right, then, folks. Well, I'm going to go ahead and do a reset for that day. Is there anything else at this time, Mr. Welch?
No, Your Honor. I think that's it.
All right, let's see if we can find somebody that's still in business down there, and we'll look at taking care of that on that date. Then, thank you.
Thank you, Your Honor.
All right, let me go ahead and make that Zoom code right now, and I'll have that out to you within the next 15, 30 minutes, Mr. Welch. All right.
Yes, Your Honor. And we'll just do a notice of hearing for this.
Okay.
All right. So, Mr. Escobedo, we've already confirmed your contact information. The notice of hearing will have the Zoom code, so you're free to leave. We'll send it by mail. Mr. Maldonado Perez, you'll get it through e-file. And then Ms. Cantu, we need to go back just to confirm it so you can get it by mail too. And I think that's it.
All right, let me get this done. Okay, Mike,
All right, let's see. Move you back, ma'am. How about to room 49?